Hi, Gary DeWall here, and this is Bridging the Week from March 10th to 14th, and today is March 17th, 2014. Good morning and happy St. Patrick's Day. No major developments occurred during the FIA's Annual International Conference in Boca Raton, Florida last week, but plenty of important regulatory and legal developments occurred outside of the Sunshine State. Personally, I enjoyed my break from the cold, gray, and snowy environs of New York City for a week, but I'm glad to be back home. There's only so much sunshine and warm temperatures I personally can take. Okay, enough about me. Let's get started here. As I stated, there were no breaking news articles at this year's FIA 39th Annual Futures Industry Conference held last week. However, some important matters were discussed there. In his kickoff presentation, Mark Weechin, acting chairman of the Commodity Futures Trading Commission, spoke of the need of international regulators to harmonize their approach to regulation of derivatives given the global nature of the markets. Along those lines, the acting chairman appeared to hold out the possibility that the CFTC may soon approve a methodology under a mutual recognition framework to authorize U.S. persons to access foreign clearinghouses based on the adoption worldwide of certain best practices for clearing initially proposed by the Bank for International Settlements and the International Organization of Securities Commissions during April 2012. Unrelated, at a panel featuring exchange leaders, there was unanimous agreement that cyber attacks are a major concern and that improving cybersecurity is a major and important challenge. There was less agreement, however, on whether the vertical organization model of derivative exchanges and clearinghouses was optimal or harmful. Bob Greifeld, CEO of NASDAQ OMX, argued that such a model was good for shareholders, but not customers, while Papunta Gill, CEO of CME Group, and Jeffrey Sprecher, chairman and CEO of the Intercontinental Exchange, claimed that the vertical model encouraged product innovation. In a panel on recreating the FCM business that I chaired, panelists were bullish on the FCM business generally, but argued that bank-owned FCM charges going forward will likely reflect increased costs of capital and liquidity that are being assessed by international regulators. Non-bank FCMs will have an advantage going forward because they will not be assessed these increased capital and illiquidity costs. But at least for now, they tend to be smaller entities that appeal to a different market segment than bank-owned FCMs. Can these smaller non-bank FCMs raise additional capital to compete more readily with their bank cousins? That will be an interesting development to follow. I found the discussion regarding the pros and cons of the vertical structure of derivatives markets and clearinghouses interesting, and one that is likely to continue for some time. However, to me, it is not all or nothing, and echoes the debates that occurred for years in the pharmaceutical industry regarding whether companies should be permitted to hold forever patents on certain new drugs, and we all know how that debate ended. Likewise, I found the discussion of FCMs and how clearing fees may evolve interesting, but to me it only highlights an equally important discussion each FCM should be having internally. Are execution fees also mispriced? As more and more transactions are executed electronically directly through fixed connections, bypassing traditional order desks entirely, orders being left for brokers to execute are increasingly more complex and risky. Are FCMs properly pricing manually handled orders to account for this risk? And finally, a topic that was whispered on the sidelines at Boca but not discussed openly. Has the demutualization of derivative exchanges and clearinghouses appropriately decoupled the relationship between clearing members and clearinghouses, where the clearing members still principally provide the financial backbone of clearing, but less and less are able meaningfully to influence the governance and decision of clearinghouses? These are all important topics that likely will be discussed more and more until the next FIA Boca Conference, which, by the way, begins on March 10th, 2015. So, get your reservations in now. The Financial Industry Regulatory Authority issued an interesting investor alert last week regarding digital currencies such as bitcoins. Among other things, FINRA noted that digital currencies such as bitcoins are not legal tender, platforms that buy and sell bitcoins can be hacked and some have failed, bitcoin transactions can be subject to fraud and theft, bitcoin payments are irreversible, and bitcoins have been used for illegal activity, including money laundering. Bitcoin, says FINRA, is a peer-to-peer payment system that uses its own currency to transact business. Regulators worldwide are assessing their ability to regulate bitcoins. The European Securities and Markets Authority gave European securities markets an overall good report card for the second half of 2013, examining conditions in securities markets overall, fund flows by investors, activity on trading venues, systemic stress, liquidity risk, market risk, contagion risk, and credit risk. That being said, ESMA identified various vulnerabilities, including those from high-frequency trading and the lower interest rate environment on EU markets. In its study, ESMA provided an interesting analysis of high-frequency trading that's worth reviewing. However, it also warned that it is, quote, investigating the topic of ghost liquidity, whereby liquidity in the order book vanishes before the transactions can be executed on the opposite side, and its relationship with high-frequency trading activity, end of quote. Last week, the Commodity Futures Trading Commission succeeded in having 3 counts of a lawsuit by the Depository Trust and Clearing Corporation and DTCC Data Repository against it dismissed. The plaintiffs filed suit against the CFTC, claiming it was unlawful for the CFTC to permit designated clearing organizations to require swap data to be reported to their affiliated swap data repositories. Among other things, the plaintiffs argued that the CFTC violated the Administrative Procedures Act when it withdrew 3 frequently asked questions during November 2012 that originally indicated that designated clearing organizations could not require cleared swaps data to be reported to their captive swap data repositories. Also last week, the U.S. Securities and Exchange Commission issued proposed rules for systemically important security-based swaps clearing agencies, as well as all other security-based swaps clearing entities. In general, the SEC proposes 2 types of requirements for relevant agencies: those for so-called covered clearing agencies and those for all others. All clearing agencies would be subject to various requirements, as they are now, under the SEC's proposal. For example, requirements regarding general organization, financial risk management, settlement, and access. However, covered clearing agencies would also be subject to special requirements related to the qualifications of their senior managers and members of the board of directors, as well as requirements aimed at ensuring the independence and authority of their risk management and internal audit functions, and the adoption of policy and procedures to address liquidity risk, credit risk, margin and collateral, as well as general business risk. Comments will be due within 60 days of the proposed rules being published in the Federal Register. And finally, the SEC charged Jefferies, LLC, with failing to supervise brokers who lied to customers about the price the firm paid for certain mortgage-backed securities, which it then resold. Jefferies' internal procedures required its supervisors to review electronic communications of its brokers and traders for, among other things, false or misleading statements to customers. However, from 2009 to 2011, Jefferies supervisors did not adequately perform this task. According to the SEC, during the relevant time, Jefferies failed to provide to its supervisors direction or tools for them to conduct their required surveillance. Although the firm employed an automated system randomly to review emails, as well as to review emails based on predetermined language searches, the system was not connected to Bloomberg Chat, where many problematic conversations allegedly occurred. Also, supervisors allegedly were not given guidance on how to review potential misstatements. Jefferies agreed to pay $25 million to settle this matters, including more than $11 million to customers. This matter also settled a parallel action brought by the U.S. Attorney's Office for the District of Connecticut. What did I say last week about the need for firms to review their emails in a systemic way on an ongoing basis? Check it out in the Compliance Week section of my article about the Bank of England suspending one of its own employees in connection with the worldwide inquiry into possible FX markets manipulation. Well, that's it for this week's Gary DeWaal's Bridging the Week. I am Gary DeWaal. Have a great week. Ciao!